Let's take you to this story now. Landlords need to take note. Once gazetted, the Rental Housing Amendment Act will make changes to the rights of tenants. The new legislation will require, among other things, landlords to provide tenants with a written lease agreement, as verbal agreements will no longer be binding. For more on this, we're joined by Grant Smear, a property expert from Epic, South Africa. Thank you very much, Mr. Smear, for your time. Now, of course, we understand that if you have an agreement that is only verbal as a landlord, that could be criminal against you.
Yeah, thanks for having me. So one of the most significant changes in the new Rental Housing Amendment Act is that agreements need to be in writing. I think what it does is it removes a lot of the previous grey areas created by verbal agreements between landlords and tenants, and clarify the rights and responsibilities of both parties.
Mr. Smear, I had no idea that there are people who get into verbal agreements with tenants for their property. How did this ever protect the landlord and their property if the tenant did something, to damage the property or something like that?
Yeah, so it certainly didn't, and that was always the issue. And what it did create is a massive amount of problems when it came to the end of agreements where tenants were asking for the deposits back and landlords were then holding them accountable for things that they might not have known about or weren't clear in the verbal agreements. It also left a lot of grey areas during the tenancy, what part of the property tenants could use, landlords, how they were accessing properties. So it really caused a massive amount of problems, and it's probably one of the best changes in the legislation, making sure people reduce their agreements to writing.
What are the other what are the other rules or amendments made to this act, for instance, Mr. Smear, whether for the tenant or the landlord? What do people need to know?
Yeah, so the Act hasn't changed anything significantly, really. What it's done is just clarified a few very important points. One of those is the right to privacy for tenants, so how a landlord can access the property for, can access the property for viewings or for inspections. So the notices are more defined. The protection for tenants in terms of shutting off electricity. I think there's a lot of cowboy landlords out there that thought that they could shut off electricity for non-payment. That's been clarified. And it's more not that it's been clarified, rather that the consequences of doing something illegal or in contravention of the Act has been clarified. So, there's a lot more criminal liability now to landlords for taking actions that are in contravention of the Act, where previously it was very unclear what the consequences were.
Now, do you know anything, Mr. Smear, in terms of the criminality, for instance, of getting into a verbal agreement? Would that mean that you have a criminal record as a landlord, perhaps if you're found to have done that?
Yeah, so obviously, once the Act is gazetted, then it will come to force, and then we're going to see potentially court cases coming off the back of that, and then we'll have further clarity on whether it will end up with a criminal record. From what I understand and from legal experts have spoken to, there is a big potential that landlords could end up with a criminal record, for example, for not reducing an agreement to writing.
Just explain to us as well, Mr. Smear, there's been quite a few people who still ask questions about, the fact that if you are kicking out a bad tenant, for instance, you need to make sure the onus is on the landlord to make sure that that tenant has somewhere to go. They will have a roof over their head. Just explain that part for us to make it more clear.
So the first thing is an eviction must be done lawfully, and it can only be done by a court order. The Rental Housing Amendment Act further clarifies that, but it's always been in place that a court order is the only way that you can evict a tenant. That court order, however, doesn't require a landlord to provide or find alternative accommodation for a tenant at all. It doesn't put the responsibility on a private landlord. The responsibility for citizens lies with government, local government, and national government. So it would be, if it was a vulnerable person, that person may have to be placed into a suitable accommodation by the local council. So that onus is not and has never been with the private landlord.
Just lastly, explaining to us the rules, if anything has changed there in terms of the deposit by the tenant. I assume when you are renting out a house, you need to pay double the amount of rent, and the half of it will be used against you later when the landlord comes in to check if there's been any damage, right? And they'll use that deposit to repair whatever damage was there. Is that still the case?
So the rental deposit is sort of region specific. In Joburg, generally landlords take you 1 month rental as a deposit. In Cape Town, it has been up to double deposit, and that full deposit can be used against any money that you owe in terms of your lease agreements or damages to the property. However, again, the current Act and the Rental Housing Amendment Act will further clarify use of that deposit. The deposit must be held in an interest-bearing account, and that interest is for the benefit of the tenant, unless the tenant agrees otherwise. So a landlord, private landlord, or an agency must put the deposit into interest-bearing account, and then when they pay the deposit back, if there's no deductions, that do then have to pay the interest back that's due on those or has been earned on that deposit. The use of the deposit is again very clear. An ingoing inspection must be done jointly with the tenant to ensure that all damage is recorded. And if that's not done, the landlord then has nothing to prove that there have been damages during the tenancy and would have to return the full deposit. So the Act is certainly clarifying use of the deposit, how inspections must be done, what must be provided to the tenants in writing at least, and attached to the lease agreement to make sure that everybody's responsibilities in terms of this agreement are very clear.
Just very quickly, the last part I'm seeing here, the right to privacy part. I mean, that's always been part of our constitution. But there are people who would say, my landlord just comes to the house whenever they want to, and they want to tell me what to do, where to put this and where to put that. What right does the tenant have in terms of law if there is a landlord who is that overbearing?
So the tenant has absolute right to full enjoyment of the property. The lease agreement that they've signed with the tenant or with the landlord, the landlord's given up their right of access to the property and their right of use and enjoyment of that property and pass that on to the tenant. They therefore don't have the right, even though they have ownership of the property, to access the property whenever they want to. And I think it's such a misunderstanding behind with property owners that they feel, well, I own the property, I can just access it. They must realize that they've given that right away in terms of the lease agreement, and they can actually be charged with trespassing on a property if they do just access it without getting permission from the tenants.
That's interesting to know. Thank you very much. Obviously, that is our property expert and the founder of the Epic South Africa, Grant Smear, speaking to us there. I had no idea you could be charged with trespassing as an owner of a property if you are that overbearing and you keep showing up at your house when the tenant is there. So remember, right to privacy.